So this is panel 2, Widowhood, Law, and Custom. Our discussant is Catherine Bolton from Notre Dame in Indiana in the United States. The first paper is Marriage, Widowhood, and Law in Angola, 1850 to 1880 by Mariana Candido of Emory University. The second paper is by me, Emily Burrell, UNC Chapel Hill in the United States as well, of Guns and Widows, the Gender of Inheritance and Accumulation in Late Colonial French Sudan, Colonial Mali. And our third paper is written by Elizabeth Thornberry of Johns Hopkins University, Refusing Native Law, Widows and the Remaking of Custom in Colonial Natal, 1875 to 1905. And with that, I will hand things over to Catherine. And I will also ask Benjamin if he might attend to time as well, because I'm on this panel and I might lose track of things, so help me. And on that note, Catherine, you have the floor.
Thanks, Emily. First of all, thank you so much. I absolutely loved reading your papers. I'm learning so much, especially from reading the historical literature on widows. So let me just jump right in. If my face changes, it's because I'm reading off my screen as well. So I'll start with Mariana's paper, Marriage, Widowhood, and Law in Angola. Which I found absolutely fascinating because of the focus on women's economic activity and marketing. And so you talk about how women in 17th century Benguela would marry foreign-born men as a source of wealth, stabilization, and security, that they were not going to be seized and deported as slaves if they were married. And this kind of reminded me a lot of transactional sex during wartime throughout history and around the world, and that women paired up with men who could provision and protect them, but they were always rendered incredibly vulnerable when widowed in these situations. And here the lens is reversed through the simple act of lawful inheritance. And doñas could provision and protect foreign men with few resources. However, I have a question for you. Once women were on their third or fourth husband, why remarry? So I asked this from the perspective of my own paper. They were likely at an age where their children were grown by this time, which would allow them to expand their power and focus fully on their commercial ventures rather than on another marriage. So what could still be gained or rendered secure by having yet another man in their lives? Which is complicated by the case of the second widow, Feliciana, which would sound very familiar to scholars of West Africa, as the age of a widow and the ages of her children means everything with respect to her social and legal vulnerability. If her children are still young enough to require care, she is less of a juridical man because she still has domestic responsibilities and more of a prize to men who would gain access to her resources by marrying her, which brings up this idea of when women are kind of useful as property versus when they are no longer useful as property. And so I'm just curious, because you mentioned in this case that she still needed her father's consent to marry, and when and under what circumstances were women in Benguela allowed to marry without their father's consent? Is it simply the fact that she becomes kind of more of a juridical man once her own father has died? Or was it just her age that rendered this a question, as we have, kind of firm lines of legal adulthood? Was her previous husband also her guardian? And if so, how did she inherit his property without a custodian? So I'm asking actually a Cynthia Enloe question. Cynthia Enloe guides my own work and my work on youth in Africa. Her 2013 book, Seriously, basically asks what it takes for a woman to be taken seriously. When is it that people are treated as individuals of consequence who can manage their own affairs? So I'm kind of asking, what is the nexus of concerns that women are navigating in order to either be given to another man, to decide to take another man, to decide to refuse another man, and how it is that she kind of gets foreign men, domestic men, and the courts to kind of take her seriously in Cynthia Enloe's questions. Absolutely loved that paper. Loved Emily's paper as well, of Guns and Wives. And I love the fact that what we see here in both of these papers is women kind of navigating new legal systems and navigating new forms of what I would call legal liminality to see how far they can push the courts to recognize their personhood. So my questions for you, Emily, was A troublemaker because she was making claims on her own behalf rather than on behalf of her children? And if, this is about her ability to claim rights for a family as opposed to rights for an individual, was that kind of the main point of leverage that she should have taken, leveraging for her children? And what made her a troublemaker was she leveraging on her own behalf. Did her status as first wife come into play? And I'm always curious about the status of first wife, because in Sierra Leone, it's very kind of shifty. First wife might have the most rights, but then she loses those if second wife produces more children. In an area of high poverty, men kind of pay more attention to their pregnant wives than their wives who have young children. And then they pay more attention to their wives whose children are of working age. So again, my kind of obsession with the age of the children comes into play here. And here we come also to something that ties us into Ben's comments from the previous panel, which is because marriages were not legally binding under colonial law, because no marriage certificates were found or produced. So I'm asking, is it possible that A's brother-in-law was making his claims based on that fact, that the women only had rights to argue their claims under customary law because they were not legally registered as MT's wives? So this seems to strike at the heart of the interface between customary law and colonial law, and the way people used one or the other to their advantage depending on the plays that they think they had to make. The colony only recognized 4 wives, so what then happened to the other 4 wives that NT ostensibly had? Are there any records of how women who were not recognized by the state lived out their lives? Where did their children go? Were they automatically kind of given to this deceased man's family? Or did these women pool their collective energy behind those women, the first 4 wives, who could state claims under colonial law? So, I mean, as an anthropologist, I yearn for these answers, even as the silences in the archival record itself effectively erase the women whose legal existence was unrecognized or unrecognizable. So particularly in light of the fact that the rights of individuals were rising within colonial France at the time, I find it fascinating that it was still the case that only certain individuals thought they could claim rights, and that juridical personhood would not be rolled out all at once, but in the same tiered fashion as governed both colonial and customary law. And this brings us very conveniently to Elizabeth's paper, Imagining Native Law, and this idea of exemption, which is completely new to me. I didn't know that there were claims of exemption from Native law that were made in South Africa. And I have some questions regarding this. I'm curious about how notions of civilization and Christianity were lumped together, that one could not have one or the other under Native law, but that one could be used to advance the other. That if women are Christian, might petition for ostensible protections of civilization, basically using Christianity to leverage better juridical personhood for themselves. So I ask this because in Sierra Leone, women often tried to resist their husbands taking other wives by becoming Christian. And essentially refusing the whole idea of polygamy. And it didn't work that often, but it didn't mean that they suddenly kind of reverted to being Muslims again. They kind of stayed the course as Christians, hoping to, through this kind of liminal place in their families, leverage more for themselves. And a question, what did Christian guardianship look like for the women who petitioned? Was it simply trading one master for another, or were there clear advantages that accrued to them by doing so? Were they all single when they made this petition, or did many of them seek a way out of their native marriages or native widowhoods? And this goes back to the question that I asked in the chat right at the end of the last panel, which is, are we looking at some kind of cultivated liminality here, by which women try to kind of leverage different sorts of personhoods for themselves? So one thing that you mentioned, it was a word that you mentioned once in your paper, but I immediately latched onto it, which is witchcraft. So the lack of prosecution for witchcraft under British law there is a reason heavily cited, moving from colonial to colonial law from native law. And I find this fascinating precisely because it is usually widows who are prosecuted under witchcraft laws. So their aloneness, at least in Sierra Leone, is socially disavowed because it connotes something that is almost antithetical to being human. So people are expected to live, cook, and eat together, and widows are the people who are least likely to have that strong social network. If, you know, as for example, in times of rampant poverty, they're not inherited by their deceased husband's families. So they have very few people who are ready to defend them. They're easy targets in times of sickness and strife. And so widows are most often the ones who are accused of witchcraft. So I'm asking if you found this was the case in the archival record. And finally, I find it curious that men sought exemption to protect their assets from what you call heathen relatives, what they called heathen relatives, including their wives and children. So this casts protection of widows and children in a new light, hinting that they might be able to take care of themselves given the opportunity. And in my notes, I actually wrote parenthetically, bated breath, could widows and their children take care of themselves? And was this kind of thinking present in other threads of the search for exemption? So I see three common threads between the papers. So one is the dynamism of women in navigating their legal liminality. In each of these cases, women saw Western law as a way of potentially renegotiating their positions, or should I say colonial law, vis-a-vis their social worlds, with greater and lesser degrees of success. So this intimates that the position of widows is not fixed in the social world, but can be negotiated through novel interpretations of juridical personhood. The second is the continual erosion of women's legal rights when it is somehow like discovered through the interpretation of colonial law that they benefit from statuses meant to protect men. So women could own property, even slaves, and inherit from their husbands variously under the statutes of law until some outraged man intervened and declared her unequal under the law. So I wonder why it's only widows who seem to be able to enter this particular arena to begin with, and sometimes successfully challenge for rights until they are once again eroded when it is discovered that they are still women. So colonial law kind of simultaneously raises and quashes the rights of widows. It seems to be a common theme that colonial powers established statutes meant to raise the status of women to the status of women in their own society, second class rather than what they would see as third class citizens in many cases, sort of running through this, misunderstanding of the various subtle ways that women exercise power under customary law. So they see some kind of barbarism in native law, but not in their own treatment of women. And this is commonly exemplified in widows because widows are the women who come before the courts with legal challenges. So I'm curious about the colonial administrative perspective on this somehow unstated need, which I saw also in the colonial horrified fascination with widow burning in India, on which there's a huge literature that white men need to save Black women from Black men, and kind of the various ways that this occurs. I hope those were useful, and I look forward to our discussion.
Wonderful, thank you very much, Kat. So why don't we go one by one? Mariana, do you want to respond to some comments, and then we'll hear from Liz and Emily, and then we'll open to the table, to the room for questions.
Well, thank you, Kat, for your comments, and I also want to start by thanking Benjamin and Emily for organizing these and bringing us together during these very strange times. I also feel very intimidated to be in a panel with people who have way more experience working on law and widowhood than I do. So I feel like I'm a newcomer. And as you can see in my paper, I have all these cases, but I don't, it lacks a serious analysis of what it means to be a widow and what it means to be able to exercise and claim rights. But I want to mention, and it's very nice to see Kat, because moving and relocating during a pandemic made it impossible to say goodbye to friends in Notre Dame. So it's very nice to see you. But also notice that I'm wearing, it's warm here, so I'm glad to be in a warm place right now. But thank you for your generous comments and the chance to keep talking with you, even being away. So one thing that I want to mention, and I will start with your last comment, your general comment on why only widows or why women who are widows were able to access this court. And I should mention that I find lots of single women as well going to the colonial courts, which is something that surprises me. I didn't expect to see so many single women, but they do show up. And this is something that I have to examine. What exactly are the differences between claims and access to resources that happen, and if there is any difference between single and widow. One of the, and I think it connects to the conversations we are having in the previous panel. What we see happening is women basically looking for spaces where they can claim some rights. So, and this creates a series of methodological problems that I do encounter lots of women who are successful in claiming property, and the colonial court is excluding people who don't have access to that. So for example, people who are not Catholics, they don't use the language of Christianity in the type of documents that I have examined, but it's very similar to what Liz was describing is happening in South Africa, in Natal. The whole idea that having a Portuguese name, being, claiming to be a colonial subject brings a series of advantages for women who are then able to exercise some claims. So why would they marry more than once? Well, I think in part because there are very few women in Benguela, and I think there is a competition for partner, for companionship, for sex, but also because these women are very well placed. So having a relationship with one of these women solves lots of problems. One of them, lodging. When you are a foreigner, you arrive in a place and you have a woman who has a house, owns lots of people who can provide service. So a union with a widow who already has the material wealth in place makes the life of foreign men very easy. And I think there was probably a competition for these powerful women. So they also see an advantage in accumulating husbands. One of the things for me, and this is one topic that I want to discuss, and I find it, so I want to hear more about other people and my panelists. One of the struggles for me is that I do work on an empire that allow women to inherit it. The Portuguese Empire, women could have guardians, but widows do inherit property. So there is a clear gain in going to a colonial court in a Portuguese Empire for women, because you can inherit it from your deceased husband. But how to write about this without glamorizing the colonial law? And for me, it's a struggle, because I can see how these can be taken out of context and create this notion that colonial law protects African women, while customary law don't. And there are lots of issues related to customary law in Angola, in part because by the time they were recorded in the early 20th century, there was already 400 years of contact with the Portuguese. So there's lots of issues related to customary law and the difficulty of historians of assessing that. I think I covered everything, maybe not, but I don't want to talk more than I already talked. And I'm more interested in listening to other people than talking too much. But thank you so much for your comments.
Great, Mariana. Liz?
Okay, so I will start by talking a little bit, picking up a little bit where Mariana left off, and talk about some of the practical consequences. So the question on, could widows and their children actually take care of themselves? So South Africa is also an interesting case legally, because although it's a British colony, it keeps Roman Dutch law from the period of Dutch colonization. So it also has a situation in which both married women and widows, but particularly widows, have kind of greater claims on property rights than they do in, say, actually Britain for a lot of this time period. Married women are a little bit more complicated because there is a legal doctrine kind of somewhat equivalent to coverture, but there is also a recognition of the ability to make an antenatal contract, not an antenuptial contract that would, you know, so you can sign a prenup to kind of split property. And it's very common, not so much for the cohort of women that are going to appear in this paper, but it's common for women who are wealthy enough that that's kind of an issue. And it's particularly common for widows who are remarrying to sign such antenuptial contracts, which give them the ability to continue individual control over their property even during the period of marriage. They exclude them from the doctrine of the marital power. What I would say is that, you know, again, to pick up a little bit where Mariana left off, what's interesting here is that, you know, this is not a kind of feminist utopia for women's property rights. There are still real limitations, but that in practice, you know, for these women, the part of what I'm trying to show in the paper is that for these women, the choice isn't between colonial law and customary law as it existed in kind of 1800. It's between colonial law and the native code, which is this very specific, deep, like, it is the absolute most patriarchal form of customary law that it's possible to imagine. It's not totally unrelated to customary law as it existed previously, but it is, you know, the absolute worst version of it for women, basically. And so one of the things that I find really interesting is that in the efforts to gain exemption from customary law, and just to be clear, you under the kind of law that creates this exemption, you have to petition as a single woman or as a married woman who is kind of part of the couple can petition jointly, basically. You can technically petition as a widow, but that almost never happens and is almost never granted because if you do petition as a widow, the rights are not retroactive, so it doesn't really gain you anything. You know, if you become exempt after you've been widowed, you don't have any claim to your deceased husband's property or to custody of your children, which I think that's nothing. I think like child custody is a really important part of this, in addition to property. Like it's not just about property; it's also about kind of family relationships. But that it's also often seen as a kind of both single women and widows who are going to petition, even though they're not currently married, those petitions are not going to be granted unless their male guardian agrees. And precisely, so it's not uncommon for, there aren't a lot of Christian women who are old enough to petition as individuals rather than as like the children of their parents and also unmarried. But when those women exist, they are usually petitioning with the support of their parents who are deeply concerned that they win exemption. Those petitions are unlikely to be granted without support of their parents, but they usually have parental support. Widows are in a different position where even if they're kind of just considering the future, often their motivation would be because they had just had a kind of negative experience. So they're often petitioning without the support of their deceased husband's family, who is now their guardian. And so they very rarely actually win exemption if they petition as widows. So most of the women who come under exemption are exempted either as children of their fathers. So when men win exemption, they win exemption for themselves and any minor children, not children who have already reached the age of majority, but minor children. And when men win exemption, they also win exemption for their wives. So that's the kind of, the typical petition is actually the petition of a man who is seeking to include his daughters or wives in this process. But so to me, one of the things I've been kind of like trying to figure out is, so there is this kind of technical possibility, and it isn't about the case like women inherit, right? Like that if you go to colonial court, like you will inherit, like that's actually interesting, like not something that's particularly contested. The real question for me has been to try to figure out like what does that look like in practice, and And so I've been trying to use probate records to do that. Those are complicated in part because probate records only exist for estates that are large enough to go through probate, which is to say relatively wealthy families in the first place. One of the things that I've found as a pattern in looking at those is that, so it's, on the one hand, there's, for all sorts of kind of structural reasons, it's very difficult for African families to hold onto property across generations in Natal, regardless of the mode of ownership, regardless of whether it's inherited to widows or inherited to like a son, which is a much, you know, more straightforward, uncontroversial process. Because the kind of primary things are that these properties are often like highly mortgaged, particularly land, and that the moment of inheritance and re-registration both involves new fees to re-register land, but also is a moment at which mortgage holders, if they choose, can essentially like call in their debt and force a kind of remortgaging. And so if that happens at a period where land values have dropped, and often African families have kind of like overpaid for land compared to market rates because there are so few people who are willing to sell to them. So they pay higher than market prices typically. So it's not uncommon for mortgage holders to then kind of choose to retake the land and sell it, partly just out of fear that the families are never going to actually pay these mortgages. But what's been really interesting to track is that even though that kind of happens relatively systematically, it's also not uncommon that essentially through kind of litigation and stubbornness, families manage to hold on to properties in effect for 30, 40 years after the death of the kind of male property owner. And that, you know, you get this kind of back and forth litigation and just correspondence in the files where like the colonial estate is just sending out more and more people to be like, you really need to kind of re-register this, you really need to, and they're just like putting people off and saying, yes, but that person has like gone to work on the diamond mines, and this person is like, you know, traveling outside of the country. And one of the things that's been really surprising is the degree to which, I mean, not everyone, and again, these are not like long-term successes in the sense that these are not families who still have that property now. Like it almost always ends up in white hands by say the 50s or 60s. But sometimes for really surprisingly long periods of time, you do find families that are able to kind of hang on to their access to property through, yeah, really sheer stubbornness. But I see that partly as being about one of the things that's really interesting about the dynamic, precisely because of what's happened to customary law in Natal, is that colonial law, like coming under colonial law, one of the things that affords you is in fact more freedom to, if you want to, have inheritance relationships and property relationships that more closely approximate pre-colonial customary law. And that's not what everyone's doing with it, but that's what some people are doing with it, right? That because you can write a will, and if you want to write a will, and because you can, you know, pass law, you can divide your property up in such ways. And it's very common that people kind of pass property down, not as divided shares, but as kind of joint owners of a property in ways that then in practice look a lot like communal ownership, but don't require the testator to follow the kind of strict rules on who, you know, essentially your closest and oldest male relative being the person in charge of the property. You can pass it down. And sometimes it's just like you pass it to your younger brother rather than your older brother, probably because you think that they're going to do a better job because the older brother is the black sheep of the family, right?
Liz, can you maybe make a closing comment?
Yes.
And then we'll hear from Emily.
But so there's a kind of way in which one of the things that colonial law does is in fact allow people to kind of have a more flexible interpretation of family obligations and inheritance patterns that, at least in some cases, actually approximates pre-colonial law more closely than the Native Code ever does.
Great, Emily?
Yeah, so thank you so much, Kat. And I'm thinking about I'm thinking about the comments that Mariana and Liz just offered too as I process my response. So to answer some of your questions quickly, your question, Kat, about Widow A's status as the first wife, I think there are a few reasons why she literally rises to the top in terms of what she's able to do here. She is also from a fairly powerful family. So I think that some of this has to do with her status and the status of her family and what she's able to there's a certain kind of leverage there that has to do with respectability and power. And the family is from the same, importantly, the family, Widow A's natal family is from the same area of the family that she marries into. So, you know, who was it that said that wives are perennial migrants? There's a historian who said this, and right now it's escaping me. In this particular case, that really wasn't actually true. So I think that she's able to capitalize, you know, she's able to take advantage of those different kinds of points of power. The other is that she's the mother of the deceased's oldest son. And so she's the mother of, I think it's 3 children, and she's the mother of the deceased's oldest son, who's also going to school and is also possibly preparing to travel to France to go to school. So he becomes much later one of this this community of students who are in France in the late 50s at university. So there's a lot that she's able to take advantage of there. I have no evidence of marriage certificates for the first 4 wives. According to the records that I have, they've all been married according to civil custom. The state recognizes these as marriages that have meaning, and actually what this means, there are a few things. One is that the state is applying a kind of codified interpretation of Islamic law and how many wives are seen as appropriate or recognizable before customary courts. The other is that it's this interesting moment where, particularly after 1952, when we have the Jacquinot Decree in French West Africa, where there's this restatement of something that first arose in 1939, which was the importance of the marriage certificate. In 1952, the state reiterates their desire to have certified marriages. And yet, even in this case, we have a civil servant from a well-to-do family. None of his wives are married to him before the state. So I'm just going back to Kat's point about juridical personhood and the ways that juridical personhood rolls out gradually. I think we see this I think we see this really clearly when we look at marriage law on paper as top-down decree, and then we look at how things are actually playing out in the courts on the ground. We can see these very fungible and complicated categories of juridical personhood in this case. Interestingly, I also have, though, I'll just say briefly, death certificates for some of the younger children who passed away. So I have death certificates in this file, but I don't have any marriage certificates, and that's worth noting, and I haven't fully unpacked that yet. The other thing I'll say is that Kat asked if Widow A is a troublemaker because she's making claims for her children or for herself. I think she's seen as a she's making claims for her children. I think she's seen as a troublemaker because she somehow wins the game against her brother-in-law, and he sees her as a troublemaker. She's the one who's living on the family compound. She's the one who remained in Sikasso on the family compound. And she's also the one who's able to position the uncle as the to go back to a term that Benjamin was using at the beginning, the paterfamilias. The uncle is the one whose power as the patriarch is bolstered by this, despite the fact that upon the death of Widow A's husband, MT, as I'm calling him, rights to the estate, custody of the children were initially transferred to the brother. In the paper record, 3 months later, we see a complete reversal. So I need to dig a little bit deeper in those court cases, in the court case and elsewhere, to see if I can trace out what really happened here. But I'm particularly gratified by the conceptual terms that you offered around juridical personhood and legal liminality, and I'm going to think through what this case helps us to understand about those important categories and also how they're gendered. And I'll leave it there so we have time.
Great, thanks, Emily. Some great comments and feedback. So questions from the audience for our panelists? Daniel?
Hi. Well, thank you very much for your papers. Your presentation was terrific. I have a sort of a question slash comment about a comment that Mariana made regarding the how to process the idea that colonial legislation was protecting women. Um, I found that very curious, but at the same time, if women wanted to take advantage of this legislation, they were also required to adjust to conform to Portuguese colonial expectations, weren't they? I mean, they had to have Portuguese names and meet some expectations that Portuguese society or government imposed upon them. So I don't think it is, a question that the legislation actually protected them, right? It offered some advantages in exchange, right, of some things that they would have to conform with. Wouldn't it? I was curious to hear about your comments about that.
Mariana?
Thank you.
Yeah, there is. So there are women who show up in the colonial courts without Portuguese name. So there are lots of Umbundo names, and there are lots of women with Portuguese and Umbundo name. So it's very clear that they are known in some spaces by one name and known with another name in other contexts. But the ones who are successful, the ones who manage to get a property recognition and custody over children, which is another issue that shows up a lot, all of them do have Portuguese name. So yeah, they show up in the colonial courts because they know that they will have some rights that will be recognized that otherwise they wouldn't have, especially when it relates to land claims. I think this is very evident. The issue is that there's this explosion of cases of women claiming land rights. And the impression is that every single woman would be successful going to the colonial court. There is an issue of overrepresentation of successful women in the courts, which is is the usual problem that historians face. What you have lots of episodes of violence in these colonial courts, overrepresentation of crimes. It doesn't mean that murder was happening all the time, these horrific murders, but we do have these records. But again, the issue is, I can see, I'm thinking here on Portuguese speaking context, okay? That I can see how this will be taken by Portuguese scholars in Portugal right now. And say like, oh, look how great Portuguese Empire was and Portuguese colonialism, how we liberated women around the world. I can see how this is going to be simplified, and this is my concern.
Thank
you. Kat, I see, and then was it Van Claire? Did you have your hand up?
So I see Emily's comment in the chat about land rights, and it's something that I think is really important we talk about is like women owning property or claiming property versus women as property. And it's this really interesting tension that keeps arising within, guardianship and claiming of children and claiming of land that women kind of hang on this knife's edge of, are they property or can they own property? And I think it's really worthwhile to tease this out.
Great.
And can I just jump in and say to that, further, not that I'm going to answer that question right now, but that further kind of continuation is that, in what circumstances can women both own property and either both own property and be property, or own property and also own other women as property?
Yeah.
Because that's clearly an implication of some of the child custody cases that I'm looking at.
Yeah, and I think one thing I just wanted to quickly add here, it's not something, you know, this goes back to what we were saying, or maybe it's something I was thinking about that came up on panel 1, which is that in a lot of these cases, what we're seeing is widows doing things that are not supposed to be possible. It's like the bumblebee flying. You know, so it's striking to me when I read this case that, you know, there's nothing on paper or in received customary law that women can own land property in their own name, or that they can even occupy it on their own terms. It doesn't make legal sense that somehow Widow A was able to wrestle this away from her brother-in-law, and yet she does. And there's clearly some paperwork here that I need to find that's not in the file about the rights of the uncle and how she's able to maybe maneuver in a certain way. But where was I going in this rambling? There's not a lot in the historical record on women and land property rights for this period of time in French West Africa, which I find frustrating and exciting in different ways. And then just the last thing I was going to say was about, I think I forgot what I was going to say, so I'm going to stop. And I just noticed that Kate just offered, I think that, just continuing to talk about women as property and women as owners of property will continue to be useful.
I think one of the things that's coming into sharper focus is just how important the fuzziness of marriage is too, right? So we're seeing a lot of these people who are either widows or who are sort of professing a widowhood, but what access to what rights and what entitlements and what property they have also turns on how real their marriage was, right? And I also see that in the cases I look at in asylum, right? It's sort of, are you really fleeing a marriage if there wasn't any marriage to talk about in the first place, as opposed to a spouse? So I think we also need to think a little bit about the terms we're using when we're talking about widowhood, because it infers a husband or a late husband, right? It infers, but it might not be a husband so much as just a conjugal partner, a spouse, a part-time spouse. You know, Mariana's stories got me thinking about the serial polyandry that I desperately try to find all the time. Occasionally, I think I found it, but it never quite shows up. Mariana?
Oh, I have lots of women with several spouses. I have encountered several cases of women, including freed women, owning property and marry more than once. But anyway, it's not the scope of this panel. But I want to go back to the question of, no, I forgot what I was going to say. About land, this question that Emily was mentioning earlier, and I think it connects to Liz's paper and what Liz was saying before, is that we see that this rush of women to go and not only have their rights recognized by others, and I think this is and widows or not, but it seems that it was important to go to the court and have this, the fact that they control a piece of land they can produce, but they can also transmit. I think the issue is also making sure that their descendants, their biological children, are receiving the same plot of land. And not other people in the family. I think there is also these disputes among families, extensive families, that become visible, and they are interesting in this type of cases.
What I find so fascinating about this is it seems to me that the legal marriage for which paperwork can be produced is both the primary basis on which women are property and both the primary basis upon which they can make their claims to property. And that, you know, in sort of customary marriages or marriages that are not codified, there's a slipperiness there that actually kind of reduces their ability to make legal claims to property, even as the marriage certificate itself is what gives, uncles and brothers-in-laws leverage to claim them as property. And yet this is the basis on which they're fighting these things in the courts. I find this absolutely fascinating.
The one thing that I would say is I think there's a lot of, kind of as Emily's failure to have any marriage certificate shows there's a lot of variation across time and space in whether colonial states actually commit to the, I mean, I feel like colonial states almost always formally commit on some level to marriage registration and that kind of production of paperwork, but there's also a lot of contexts in which that commitment is extremely nominal and they're forced, and that's part of what forces them time and time again. But then they come up with other ways of kind of like proving marriage, precisely because so few people actually go through the kind of formalities of legal registration. But just to say that also that I think in the context that I'm looking at, part of what's interesting about exemption is precisely, and this speaks, I think, Kat, to your earlier question about civilization and Christianity going hand in hand, is that one of the reasons that exemption, I think, is felt and comes to revolve around widows in particular, that debate, is precisely because there are legal consequences to Christian marriage. So if you take a Christian marriage, you cannot legally marry a subsequent wife by customary law, right? I mean, people do it all the time, but those marriages don't exist in the eyes of state law. They're just kind of fancy forms of adultery. But one of the things that actually the people who kind of lobby for exemption would have liked to see is they would like to see marriage by Christian law essentially create exemption by itself, right? They think that if you marry by Christian law, you marry by Christian rights, not only should that the legal consequences of that marriage should include particularly inheritance that follows the norms of colonial law rather than the norms of customary law. And so for them, it's already a compromise that you have to kind of go through this exemption process, because to marry by Christian rights should in and of itself mean that you've kind of committed to civilization to a degree that should have these other legal consequences. And so for them, it's a kind of slipperiness on the other side where you are married, but that marriage doesn't have the consequences that they think it should, right? It's not, there is a sense still in which is not like, for them, a real marriage in the eyes of the state, precisely because that they really recognized it as a kind of Christian marriage in the way that white people's Christian marriages were recognized. You wouldn't need to have exemption because the state would just see that in and of itself as a reason to have inheritance happen according to colonial norms.
I think another theme that I see is sort of emerging throughout all these papers so far is the sort of relationship between protective, the way widowhood is framed as something to be, or the types of widowhood practices are framed around protection and concepts of protection, whether it's legal protection or whether it's just sort of a patriarchal narrative of protecting vulnerable people. Obviously, Levirate and Sororate is framed as a way to protect vulnerable widows from being abandoned, or unfortunately, we don't have a paper on Ghanaian witch camps, but there's quite an interesting rich literature on these camps that are inhabited by many elderly widows. And I see that through these papers too, I think we need to think carefully through how we narrate all these different conflicting versions of protection. And actually, just before we take another question, we still have a few minutes. I just want to recognize that Wesley Alubo joined the room. I don't know if you can hear us, Wesley. If you want to turn your camera on and say hi. Wesley I don't know exactly how it came to pass, but anyway, there is a paper. Wesley's paper does exist. It's going to be uploaded to the Dropbox. He was originally part of this panel. You're muted right now, Wesley, but anyway, so just that will be added to the slot and to the box for you to read. Anybody like to make some final comments or thoughts?
Can I say something if nobody else has anything else to add? It's just a separate thing I want to underscore as maybe a request for future talking. So we've all read Burying SM, or maybe not all of us, but some of us, especially maybe the historians who come from a particular social history tradition, are familiar with Burying SM. One of the things that I find really important that I would love for us to continue talking about is this phenomenon of when women make, thank you, Benjamin, when women are willing to go to battle with their brothers-in-law. So this goes back to this other point about fighting in battle. They're accused of not knowing things. That this idea that women's knowledge is compromised knowledge is a fascinating, or that widows' knowledge in particular is compromised or somehow incorrect information, is a really interesting thread for me that I would love to hear more about as we move forward through the panels today, because it's something that I see coming up in my paper, and it seems like it's maybe coming up in some of the other papers on our panel, that when women go to court, even if they're grappling with levirate in different ways and they are pushing against it, they're accused of having bad knowledge. That's all I just wanted to say there.
Okay. Well, why don't we pause now? We've got about 5 minutes, and then we'll resume again. So, for those who have just joined us, we're just going to pause for 5 minutes, take a break. Emily will pause the recording, and then we will return to the next panel. Now, I do realize that some of you don't read Portuguese. There are 2 papers in there that are written in Portuguese. My Portuguese is not as good as it used to be, but I'm going to do my best to help, for those of you who don't understand Portuguese, understand the content of those papers in the next panel.
Okay, so we'll see you back here in a few minutes.